right, we are here with Judge Melissa Bellan of County Court Law number 2. Bum, 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 bum. We are here for this installment of DTLA. Here comes the judge. Best courtroom practices for Dallas judges. All right, Judge Bellan. She has been on the bench since 2018. I've had the honor to have known Melissa for a number of years. I guess we first met each other through the Democratic Party, and Melissa was doing all sorts of fun stuff and doing some election cases and some crazy things with that. And gosh, it was an embarrassing amount of time ago, which I will not talk about when we met.
It probably have had a teenager by now. So yeah, it's been a while.
Yes. Our friendship has had a teenager. And over the years, she's become one of Dallas County's just most thoughtful and just great jurists. And it's just been a real pleasure to watch her and see her on the bench. And I am just super stoked to, get some inside ball on how her court operates and some of the best tips and practices for it. So I'm going to jump right in with some hard-hitting questions like, what things do you see the best lawyers doing in your court?
Well, this one's a little bit hard because I want to try to give y'all stuff that works for the everyday, because I've seen some amazing things in trial, but y'all aren't going to necessarily get to steal all of those things for a regular hearing. I would say the things that the best lawyers do is that they, one, are prepared, but two, they know enough about the court they're in to anticipate some of the things that we might ask of them. For me, if there's, some procedural issue that someone has raised, you're going to want to address that before you launch into your big argument, because like most judges, if there is sort of that easy softball way to kick either an issue down the road or that, it can't be addressed at this time, I don't want to waste 30 minutes of your time hearing your best arguments if I'm going to have to reset you because of a procedural issue. So I would say being streamlined, being prepared for what may come as issues, and being ready to address those in any order.
Gotcha. So in that same zone, what are the things that are your biggest pet peeves of when lawyers come into your court?
My biggest pet peeve is the lack of a real conference on things, because I know how many of you all need the limited hearing slots that I have, and nothing drives me crazier than getting to a motion to compel where it's either clear they haven't talked, and after talking to them for 2 minutes, we figured out we're not ready to tee up these issues, or that the issue has been resolved, but no one canceled their hearing. Yeah, I mean, those are really the big things, because for me, it's not so much like I'm going to be here regardless anyway, but I don't want to lose hearing slots that another one of you could have used. I had a motion today where it is clear that things got amended between the original filing and now. They should have had an additional conference about what was remaining. And instead, I couldn't go forward today because the old responses were the only thing that was in front of me. No one had amended, no one had supplemented. So make sure, and particularly with your staff, because I know they do a lot of the heavy lifting on these things, but they've got to make sure that the court has what it's going to need, or give that slot back and get yourself another one.
Oh, that makes sense. I certainly, in this universe, and especially with just the limited amount of slots, like someone just like wasting that is just, it hurts all of us. So that makes perfect sense. Kind of in that vein with those limited slots, for you, every kind of court handles a little bit differently. What are the best ways and procedures to get hearings in your court?
So I've now set up 3 different kinds of dockets. We have an in-person motion docket, we have 2 virtual motion dockets a week, and we have 2 submission dockets a week. So I'm trying to make it so you should always be able to get in front of me in some way. It may not be your number one choice. You may really wanted to have an in-person hearing, but if a virtual hearing is going to solve that, or if we have an issue that can be done on the paperwork, I love to take up things on submission. Some of it's just the really easy stuff. A lot of times, when y'all are just trying to get an order walked through, because we aren't the same way we used to be, where lawyers could just come back and find a coordinator or a judge and say, hey, can you get this agreed scheduling order signed for us so we can move on? That gives you a chance that if for some reason it hasn't just automatically happened, because I try to sign anything that's agreed for you guys, within a couple of days, so you're not waiting on it. But that submission docket gives you yet another space where if there's something that just needs to get in front of my face for me to sign it for you, that lets you have another slot to set those. So you do know what kind of hearing you're setting for, because it's different days of the week. You do need to make sure, and under the new 21 rules, you also now have to tell folks how the hearing is going to happen in your initial notice. Our Zoom site is published on our webpage. So if you set a virtual hearing, you should be able to go grab that, put it right into your notice letter, and then you won't run into that issue. If it's in person, please put that in bold, because folks aren't quite used to being back in person. And, and I also do now have the ability to do hybrid things now that we've got the new AV system. So say somebody wants to have an in-person hearing, but you've got to be in Houston for another hearing. You just, let the court know I need to appear virtually for this. And unless it's something that I need your body in the courtroom for, like a show cause or something, we will always try to accommodate you.
So one other kind of universe, how to approach with emergency issues.
Okay. Yes. And one thing I didn't say about those settings is all of those basic settings go through the clerk's office. Please do not coordinator for your regular run-of-the-mill setting. If you have an emergency, for instance, or you have a TRO, or you have something else that we are not going to be able to get in the regular course of things, then please reach out to my coordinator. And I will tell you that email is best, because a lot of times our staff, they don't know all the intricacies. And if they will forward me an email that you have sent, I can often tell exactly what it is you're asking me about, even if maybe the coordinator doesn't pick up all the things between the lines. So I suggest doing it in writing, because that way she can tell me exactly what you all requested. There's no game of telephone with misinterpretation. And, unless I have not yet had a circumstance where we could not figure out a way to hear something on an emergency basis. I suppose if I was out of state or something, then I would find you another judge here.
Okay. Now, as of this point, you don't have in the county courts like any of the associate judges or anything else like that.
Correct. We are the only court group that does not have any assistants, whether that be associate judges or a court administrator or staff attorneys. What we do have right now is a backlog court that was set up through the commissioners with the COVID ARP money. But that is a limited program, and its purpose was to help us get the extraordinary amount of eviction appeals that we've been getting back on track. But the good news with that is now that we are on track, we can expand those visiting judges to hopefully do some additional things. We're hoping to get them to help us try level 1 cases, so that you can actually get a level 1 case heard in the time period that you're supposed to. Right now in Dallas County, that's just unlikely given the number of settings we have. So we don't have associate judges, but we do have visiting judges who are here on a regular basis in that backlog court. And if we go to conferences, or if I don't know, sometime I'm going to take a vacation, also can get visiting judges to come sit for our docket. But you should always be notified. For instance, I had appendicitis in 2022, 23, I can't remember now. And I was unexpectedly out, and we got a visiting judge to come cover some things. And then instead of our usual process of posting that there would be a visiting judge so you could object, clearly that happened on the fly. And so folks did not have as much notice. But for instance, if we set a level 1 case with a visiting judge, you're going to get a new trial notice that says that that is a visiting judge, so that you get that opportunity to make the objection. Now,
just one point of clarity there. With those visiting judges, that's not something that you can request. Like you can request for a associate judge in the district courts. Am I correct there?
Correct. Right now,
assigning.
Yes. So right now, the only way you get to the visiting judge through our backlog is if the judge has assigned a case over there. And right now it's mostly just our eviction appeals. But you certainly could ask me if you're trying to get a sooner setting and you know you're not going to be able to get in front of me and you're willing to be heard by a visiting judge. I will absolutely find another space in this building to put one of us in and see if we can run, 2 dockets that week. I will always try to get you guys a solution if there's one to be had.
Sure.
And always for the trick that you only get to object to one visiting judge. So if we have 2 in the building and you go to the first one and somebody objects, we send you to the second one, you're stuck.
So yeah, you only get one. Okay.
Right. Or what happens more often is Judge Chatham has been sitting in our backlog court, and he and I play the game where if somebody objects to him, they're like, "Oh, well, Judge Bellan's here. She'll hear you." And then they're like, "Oh, no, never mind. We'll do it with you."
Yeah. Yep. So kind of the things that we deal with, like one of the big meats of it is dealing with discovery and discovery disputes, of course. And so, every judge kind of has different preferences on how they like stuff to be brought to them. But in regards to discovery disputes, motions to compel, you already kind of said that one of the big things is, make sure you've done your conferences and you've actually, looked at these stuff and you're not wasting your time and or the court's time. But let's dive into that just a little bit deeper. So, what are some thoughts on, the motions to compel and those discovery practices, in your court, and best practices for them?
Right. I mean, one, I would caution both sides. I mean, make sure that your stuff is right. I mean, you all often, you'll notice a deposition and you'll just get a motion to quash and they'll say it's because of date and time, but they don't provide any proposed alternate dates and time. That's something they are supposed to do. That's probably a conversation y'all want to have before you get in front of me, because if I'm asking the question of, okay, well, you didn't provide them with any alternate dates, so what are we doing here? I want us to be at the hearing where they can give you those dates as opposed to telling me, oh, well, Judge, we'll find some dates and get them to them. Because I find, at least when I was practicing, the least useful type of discovery hearing I would have is when we kind of talked about things nebulously because we said we were going to go deal this, or I had to talk with the client. And then the result is we'd leave a hearing, we'd have some direction, but we didn't actually get anything fully accomplished. And then you get busy and you forget to respond to an email. And the next thing we know, it's a month later and we still haven't gotten things squared away. So I would prefer that you all, to the extent you can, consolidate issues. I don't want to see a motion to compel on Monday about the deposition of Bob Smith and another motion to compel on Tuesday about the deposition of Sally Smith. Like, if we could set those things together so that I can get you as many rulings together as we can, make sure you put in good proposed orders. It is really helpful for me to have the ability to grant, deny, or modify on each, if you have specific discovery requests that we're going through.
Okay, so kind of a list order.
Yes, because then you actually get an order from me that day, as opposed to us talking about things, you guys going back, trying to work on a form of an order, and then we get into that same, spiral of it might go off the rails at some point from there. But look, I think probably it's one of the biggest parts of our jobs. The biggest part of my job is to make sure that you all have what you need in your cases, and almost every time that's discovery. So I don't understand. I know it's frustrating sometimes. I know we hate seeing the same thing over and over, but the fact is that's what it takes to get these cases ready. And so I can't just be a judge who's like, oh, I hate discovery disputes, because I don't, one. Two, it's really vital to your case. And that's what we're supposed to be here for, is to help you get the case to a position where we can actually either resolve it because we have information or try it because we have the right information.
What are some red flags to you that someone's maybe abusing the process?
If you are not providing the things that are required in the now standard initial disclosure, that is a giant red flag to me. And I've seen that a couple of times lately. When I see there might be another insurance agreement, but we don't have to give it to them, or there's a settlement agreement, but that other person isn't a party, so we don't have to. I think it's a red flag for the attorney on the other side too, where they're going, well, there's something about this they don't want us to see. The other thing is when I start getting into the semantics battles with folks, sometimes it becomes very clear to me that the reason we haven't answered a question is because if we answer it, it's not good for us. So instead, we'll argue about the form of the question or whether, that meant of all time or if that just meant recently, we'll start seeing those sorts of answers. I had something recently where there was a fight about, I think it was an issue about whether we were going to go to arbitration, but someone got the clue that the arbitration agreement wasn't signed at the time that someone was alleging it was. And we went round and round and round and round trying to get somebody deposed when what ended up happening is the attorney ended up stipulating to when it happened. And that saved everybody a whole bunch of time in having to fight through that. But it was clear they didn't want to give the answer on the front end. And still nobody wanted to swear to it, but they would stipulate to it. And so sometimes, there must be something else going on if I read between those lines. But most of the time, I never get to know the really good, juicy stuff behind the reason.
But you can smell it.
Yeah. I think anybody practiced, especially anybody who did litigation and has been in discovery fights, we've all been on the side of bad facts for our client, where you dress them up as best you can, but you have to disclose them. You can't just hide the ball on them. And so I don't see it very often, but when I do, it is really obvious that that's what's going on. And a lot of times counsel will kind of give you the look like, Judge, I have to take this position because my client is requiring me to take this position. And we know it's not because you all are trying to do something misleading or nefarious, but you have duties to your clients. And sometimes that's just how a case is set up.
One time we had a particularly disputed case with an old gruff attorney, and eventually they had to give up the goat on the issue. And he said, Paul, there's just only so much lipstick you can put on a hog. And I was
Exactly.
like, all right, that's awesome.
But you were doing a good service to your client by picking out that color.
You tried to. That rouge did not work.
You did your best.
Well, okay. So switching gears a little bit, kind of getting into the nuts and bolts of trial. How long do you give parties for voir dire?
All right, I'll give you the best answer that everybody always wants. I don't limit any of these things, especially voir dire. My personal opinion is that voir dire is the most important part of trial. I don't think you necessarily win a case in voir dire, but you can definitely lose a case in voir dire. And I don't know, I personally think that I could pick a jury for a simple contract dispute in probably 20 minutes, but I would need 45 on what we call a simple car wreck, because things like the burden of proof, things like cases may have issues where you have a driver who is uninsured, or maybe you have a non-resident alien, and you have to get through those issues with your jurors to make sure that that's not something that's going to, be a bomb that's just waiting to go off in your case. So what I do is I ask people to give me an estimate of how much time they think they'll need. I will always equalize time. That doesn't mean that you have to use all the time that your cohort did. And usually I just give people a signpost when you're getting close. Like if you tell me you need 30 minutes, I'll say, hey, we're right about 25 minutes. That doesn't mean you have to stop in 5 minutes. That's just me saying, hey, this is about how much time you thought you needed. So let's make sure we're using our time wisely. And the other side can object to you if you're beating a dead horse. I will tell you to move on if I think that's what's happening. But that has never happened. I have never had an instance where I felt like I needed to limit voir dire because we were not using time wisely.
Okay. And kind of in that same universe, how about for openings and closings?
Same thing with those. I ask for time estimates. I will equalize time. My only rule on closings is if you're the plaintiff, you have to fully open your close. You can't save your best issue for your rebuttal so that the other side doesn't have a chance to respond to it. So you need to fully open your close, then let them have their response, and then you still get your rebuttal period. And again, I ask folks, how much time do you want to reserve out of your chunk of time? And the only time that ever comes into play is I have before given time limits for the totality of a case, but I always let counsel decide how they want to divide that up. If you want to save 2 hours of your time to do a 2-hour closing, you can do that.
But this case is going to be done in 2 days.
Yes, you've got 25 hours on the clock. You can use those 25 hours however you want.
Okay. All right, well, let's see. Are there any other kind of court-specific protocols you may have that you good for people to know?
I would say the only one that I'm a real stickler on is any dispositive motion, including summary judgments, motions to dismiss, anything else that would get rid of all or part of a case. Those need to be heard 30 days before trial. I always write that into your scheduling order if it's not in there already. Most folks know that that is a requirement I have, so I see it a lot of times in the scheduling order. But that's really the only other kind of hard and fast rule I have about timing of anything. It's just because I just know how hard it used to be to get ready for trial when we still had a summary judgment hanging out there that we might get to talk about in pre-trial, but we might not. So I want to have dispositive issues addressed 30 days before. And of course, if something new comes up, if there's an emergency, if there's new facts that are discovered, I will always hear you out on whether you need to leave for a shorter period, or most of the time people will end up asking for a continuance of the trial date, and then they'll set their motion once they get their new trial date.
Yeah, that makes perfect sense. Well, okay, that's about all I have. One last question is for young lawyers that are practicing in your court. What are some practice tips that you think would be useful for them?
I think the best thing, and it's hard now because there's just not as much activity down here as there used to be. But if you can, whether it's virtual hearings or in person, if you can steal a little time, if you get sent down on a quick prove-up motion and, look around the floor, see if anybody else is having a hearing, and take 10 minutes, go sit in the back and watch how other judges do things, watch how other lawyers do things. Because it's rare that you find something that you can sort of wholesale steal from someone, but almost everything you can turn into your own style. And that's sort of my other preference for young lawyers, is just, you're never going to be whoever it is that maybe you admire, whether it's Atticus Finch or whether it's Paul Wingo. You're never going to be Atticus or Paul, but you can be the best version of you who has seen some great tools that Paul or Atticus uses that you can make your own. But juries will know in a heartbeat if you are just reciting what someone else put together as a presentation. They, better than judges even, those jurors will figure you guys out in about 5 minutes. They'll know how you feel about your case, they'll know how prepared you are, and they will know whether you have taken control in the courtroom or whether you are sort of coming from a position of being reactionary instead. And that works with judges too. I mean, judges like folks who are succinct and prepared and can direct us to whatever you think is the most important point where you can get an easy win on your motion. If you've got 5 winning arguments, figure out what is the easiest, best one, lead with that. And if that's unsuccessful, then we go to number 2, 3, and 4. But if there's an easy way to punt something where you win, let the judge know, because a lot of times we will take you up on that offer.
Oh, nice.
Of course, join these organizations, come to the meetings. Even if it is not because you want to come for the CLE, it's about the networking. It's about having an attorney that also does the same kind of work, that when at midnight you're trying to scramble to get something ready, that somebody you can call to just say, hey, am I screwing this up? Do I need anything else? Have I done the right thing? There are so many lawyers who are willing to give you their help and information, but they're not going to seek you out. They're not going to come to you and say, I would like to be your mentor. Sometimes it's a squeaky wheel. I have a feeling, Paul, like me, you were never shy about asking somebody or their idea or their, hey, do you have an expert depot outline that I can crib from? We spend all of our time in school being told never to plagiarize anything, and then we become lawyers, and it's literally malpractice if we don't plagiarize things, because otherwise we're wasting time reinventing the wheel. So use those opportunities. There's tons of great info out there that you can get from other folks. And, come to the CLEs, get involved in the various organizations, and meet some of those folks who will be willing to help you, when you're having that panicked moment late in the day or early in the morning.
Well, I still have those. Those don't seem to go away, do they?
Happen. And and what's amazing in this job is I know that there would be tons of areas of law that weren't necessarily what I practiced, but it's still amazing to me sometimes where people will come in and they'll be asking me about some small section of the CPRC, and I'll be like, I don't know if I've ever even read this section before. Thought applied in a case. And we do the same thing. I go to the judges who have been here forever and say, hey, have you ever seen this before? Or have you ever had this argument, or how do you address this? And I'll tell you the truth. We talk about lawyers too. We'll say, hey, so-and-so was in my court today. And most of the time it comes from a place of concern because we're like, I've never seen so-and-so act like this. Have you seen this before? And sometimes you'll hear, oh yeah, that's their stick, or no, that is a little weird. And, so you're all human. And so are we. We have bad days. You have the bad days. And there are days when a lawyer that I know usually makes the best arguments is just off. And that means that then I need to spend more time in the briefing because I know that lawyer is usually very prepared. I know they're not going to be telling me something that's unclear. And it just means I need to dig in the papers a little bit more to find the argument.
Well, I appreciate you taking your time, Judge. This has been insightful and wonderful as always. So thank you very much for being on DTLA's Here Comes a Judge. Ba, 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 ba.